Greetings and welcome to Constitutional Law, Freedom of Speech from American Jurisprudence. Before we get started, just wanted to ask everyone to please hit the like, make sure that the notification gets out there. I noticed that the notifications have been kind of slim lately, so let's try to get the word out. As always, we'll have at our side Black's Law Dictionary, 9th edition here, just to make sure we leave no word behind. Let's get started. So we're on to American Jurisprudence, Constitutional Law. We're going right to the section regarding freedom of speech. And this is section 458, freedom of speech and press generally. And this is from the May 2022 update. Let's get started. Section 458, freedom of speech and press generally. Constitutional protection. And before we get started, just want to make sure that everyone's aware this is strictly for the entertainment educational purposes of the YouTube broadcast, not to be used, construed, or performed for any kind of personal, professional, legal, lawful, financial, tax, or otherwise. Please don't do this at home. And let's continue. The First Amendment to the United States Constitution and most state constitutions. Hang on a second, this isn't centered well here. Give me a moment, let's make sure we don't leave anything off the screen here. Yeah, it looks a little bit better. Nope. How about that? There we go. All right, the First Amendment to the United States Constitution and most state constitutions contain express prohibitions against enactment of laws which would abridge the freedom of speech or of the press. Before we go any further on this too, I also wanted to mention that there is a lot of confusion about what rights the First Amendment actually protect. A lot of people that claim to be First Amendment auditors or members of the press or expressing freedom of speech. So let's revisit this through the lens of common law and with American jurisprudence here to give a more, I guess you would say, a formal rendition of these secured rights and take them in that context and then reassess how we label things because they're more in how they're done, not just what they're called. Let's proceed. The rights to freedom of speech and freedom of the press, as guaranteed by the First Amendment, guaranteed, not provided, are fundamental constitutional rights, and a party alleging violation of its First Amendment rights must show that the challenged government action actually regulates protected speech. The First Amendment's guarantee of free speech does not extend only to categories of speech that survive the ad hoc balancing of relative social costs and benefits. The First Amendment itself reflects a judgment by the American people that the benefits of its restrictions on the government outweigh the costs. Let's catch up with some of these footnotes. See where they're coming from here. Footnote 1. And this is a 2011 case. Interesting. The sensitivity and significance of the interests presented in clashes between First Amendment protection of speech and state law rights counsel that courts rely on limited principles that sweep no more broadly than the appropriate context of the instant case. That's pretty good. The sensitivity and significance of the interests presented in clashes between First Amendment protection and state law rights counsel. Let's see here. The sensitivity and significance counsel. I get it. You have to read very carefully, especially when they're condensing these footnotes here. All right, so the sensitivity and significance counsel that courts rely on limited principles that sweep no more broadly than the appropriate context of the instant case. Great wording there. The state constitution provides protection of speech independent of the First Amendment. And that is a 2008 case. For discussion of protected symbolic and nonverbal speech, see sections 528, 533, and generally as to application of the First Amendment to the states through the 14th Amendment, see section 414. All right, so that looks like footnotes 20 and 21 look like they should be interesting. Let's proceed. All right, and before we do that, let's pop over here to the chat and see if everyone's here. Looks like Audit Them's made it. Great. Anyone else is here, please pipe up in the chat so we know the word's getting out. And let's continue. All right, so what we're seeing here is that First Amendment rights must show that the challenged government action actually regulates protected speech. And of course, that's that instant case. The First Amendment's guarantee of free speech does not extend only to categories of speech that survive an ad hoc balancing of the relative social costs and benefits. This is a very important statement here. It doesn't only extend to the categories that survive an ad hoc balancing, so at the particular instant, of the relative social costs and benefits. So notice how we're stacking on qualifications here to these costs and benefits. The First Amendment itself reflects a judgment property by the American people that the benefits of its restrictions on government outweigh the costs. And we can't be deprived of our property without due process. And the Constitution forecloses any attempt to revise that judgment simply on the basis that some speech is not worth it. Wow. Any attempt to revise that judgment simply on the basis that some speech is not worth it. Speech as protected by the First Amendment extends to many activities that are by their very nature nonverbal. But whatever its source, there must be some outward manifestation of the allegedly protected First Amendment activity, since a defendant's assumptions and bad motives, standing alone, do not create First Amendment liability. So there must be some outward manifestation of the allegedly protected activity, because defendant's assumptions, again, staying away from assumptions, presumptions, conjecture is the approach I try to bring forth here. I'm not trying to take sides on anything, just presenting as much information here from American jurisprudence is probably the best presented we can find these days from erudite sources on the common law that's kept up to date. That being said, the defendant's assumptions, bad motives, standing alone. So it must have some outward manifestation of the allegedly protected First Amendment activity. Important case there, that's number 6. Let's look at that one again, see if there was any, discussion of protected symbolic and nonverbal speech. So it goes a little bit more on that, and that's from the 5th Circuit, 2008, Jordan versus Ector County. All right. Free speech is not restricted to compliments, and members of a free society must be able to express candid opinions and make personal judgments. Those opinions and judgments may be harsh, critical, even abusive, yet still do not subject the speaker or writer to civil liability for defamation. Now that's an interesting point there. Let's jump over here on the chat really quick. All right, we have Tlatwani. Welcome. Greetings to you. I'm glad to see you here. And anyone else that's here, Please join in on the conversation and pipe up with any questions you might have along the way for clarification. As I'm reading along with you guys here and trying to keep on top of every concept here to make sure we leave with a full understanding and not jumping over anything that's necessary to get the totality of the information understood in a way we can use it. All right, let's continue. Ordinarily, governmental entities have some leeway to proscribe certain categories of speech among citizens to promote the efficient performance of governmental functions. There are certain governmental functions that cannot operate without some restrictions on particular kinds of speech. However, the First Amendment does not permit the state to sacrifice speech for efficiency. Oh, now this is interesting here. The governmental entities prescribe certain categories of speech among citizens, operative word here. And remember, these citizens are employees of the government because it's their duty is performance of governmental functions. And some of those governmental functions cannot operate without some restrictions. So cannot operate is not simple efficiency, it's efficacy. However, the First Amendment does not permit the state to sacrifice speech for efficiency. So here we have a citation to make that distinction even more clear, that it has been recognized by an appellate court, I would assume. Let's see. Footnote 9, National Institute of Family and Life Advocates versus Becerra. And that's 2018. We also had the Arizona Free Enterprise Club's Freedom Club PAC. Oh, wow. Versus Bennett. This must be an interesting one here, too, in 2011. And these are directly relating. This is footnote 9. So that's relating to the efficiency. Observation: illicit legislation intent is not the sine qua non of a violation of the First Amendment's speech guarantee. And a party opposing the government need adduce no evidence of an improper censorial motive. I like these big words here, but let's break it down a little bit. So, illicit legislation. Now, when they say illicit legislation intent is an interesting concept. Let's see if it's elucidated here in the footnote. No, it's just going to be the citation from 2015. So let's break this down a little bit here. The illicit legislative intent is not the sine qua non, and that would be what is necessary here. Let's look up the Latin on this for everyone, so you're not just going by my word on it. And we should be able to find that easily in Black's Law. Okay, so again, this is a scanned copy. Bear with me for a moment while we get to the S's. Sine qua non. Non. I think non is better. All right, we're almost there. And as we go along the way, any serendipitous notations of these words here that you'd like me to break down even more, we can always come back to. It just takes a while for it to catch up with the scroll. There we go. This is a scanned copy here, so it's from image, not just text. And the live streaming software doesn't like it very much like this. All right, we're almost there. Ah, geez. It overshot it big time there. I can't stop it. All right, let's get back to the S's. Jeez. Went out of control there for a moment. All right. And there should be a few of these not without the other or first or whatever, because there's a lot with the Latin terms here. Slavery, a situation in which one person has absolute power over the life, fortune, and liberty of another. 2. The practice of keeping individuals in such a state of bondage or servitude. Slavery was outlawed by the 13th Amendment. It was also outlawed in the Northwest Ordinance. Kind of peculiar at something mentioned there, huh? Almost there. Here we go. Sine qua non, or sine qua non. Noun, Latin. Without, which not. So without, which not. An indispensable condition or thing, something on which something else necessarily depends, also termed conditio sine qua non. So good to know these terms. Sine qua non is a very common legal term, Latin, and understanding that it's something that's used frequently, it kind of implies some type of legal knowledge. The fact that you're using it for such a common occurrence, an indispensable condition or thing, something on which something else necessarily depends. So getting back to where we were in the presentation here, thank you for bearing with that digression. When they're talking about the illicit legislative intent is not the sine qua non, the indispensable part of the violation of the First Amendment's free speech guarantee, and a party opposing the government need adduce no evidence of an improper censorial motive. Okay, so illicit legislative intent. Interesting, illicit legislative intent. I think that's bears actually breaking down a bit there too. Illicit used in a legal context here would be an interesting word to see, because I'm curious how it applies to legislative intent. How would legislation be illicit in the first place? Makes wow, this thing's really jumping around a lot. All right, we're on E. We should be there shortly. Wow, it's really going a little slow here. Here we go. Illegal. Illegitimate. Illicit. Illegal or improper. All right, so in this case, improper, I believe, would be the one. Illegal, but gosh, it'd be hard to imagine legislation being facially illegal like that. Okay, so prohibited legislative intent is what they're saying here. Getting back over to this. Is not the indispensable part of a violation of the First Amendment's free speech guarantee. And a party opposing the government need not adduce. So induce, reduce, produce, adduce. Seems like Latin prefixes again. And I don't know about you guys, but I'm rough on my ad is out. Oh Lord. Okay. Let's just look it up. We're almost there. It's salute to you all for sticking around with this. This is the scanned version of Blacks is probably the most annoying part of this. And why I like paper copies, because you have the tabs at the top of every page. This one's every other page where you can see where you are. So we're at the ANs. I just don't want to jump over it too quick because it'll... All right, we'll do one big jump here, see where it takes us. And we are at agreement. We'll go a few more like this. We should be the D's. A lot of agencies. Okay. All right. So we're on the advice, all that good stuff. Adverse possession, the enjoyment of a real property with a claim of right when the enjoyment is opposed to another person's claim and is continuous, exclusive, hostile, open, and notorious. Excellent. All right. Let's get to our word adduce. I can't resist doing that, stopping off at different words along the way. That's another serendipitous part of having the paper volume in front of you. Of course, you can get carried away with that too, like scrolling. Here we go. Oh, Lord. With this terrible image document here. All right. So we're getting close here. Addition. All right, we're getting close. AmJur. Oh, I missed it, didn't I? It's up here. Adduce. Verb, 15th century. Ooh. To offer or put forward for consideration something as evidence or authority. To offer to put forward. To offer to put forward for consideration as evidence or authority. Adduce the engineer's expert testimony. So to offer or put forward. Okay. New word. It was worth the diversion. All right, so now we can actually fully understand the complete meaning in the context of this observation. So the illicit, the prohibited legislative intent is not the indispensable part of a violation of the First Amendment's free speech guarantee. And a party opposing the government need not offer up any evidence of an improper censoring motive. Okay, if we're all clear on that, let's move on. What this is saying here is that you're not going to have to show any evidence of them having an improper motive to censor because of the illicit legislative intent if there was a violation of a free speech guarantee. That's not the indispensable part. And there'll be no need to offer up any kind of evidence of an improper motive. So the intent and motive is not necessary for the government to commit a First Amendment free speech guarantee. Footnote 10. And there's it, 2015. So this is very current. It is established that the same fundamental principles which are contained in the First Amendment protect the rights there enumerated from any state abridgment by virtue of the Due Process Clause of the 14th Amendment. The rule is that the rights of freedom of speech and of the press are among the fundamental rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by state action, and that any government action which chills constitutionally protected speech or expression contravenes the First Amendment. Government or state action includes a municipal ordinance adopted under state authority, and state action accomplished solely by judicial act, as where injunctive relief is sought against personal defamation. The First Amendment protects a person's right not only to advocate a cause, but also to select what they believe to be the most effective means for so doing. See, this is important here. Protects a person's right not only to advocate a cause, but also to select what they believe to be the most effective means, not efficient, but effective. So the First Amendment protects a person's right to advocate a cause, but also to select the means for doing so, what they believe is most effective. That's all that seems required. That's footnote 16. Here's your case: Citizens for Tax Reform versus Dieters, Sixth Circuit, 2008. All right. Select how they believe most effective means for advocating your cause. The First Amendment right to free speech does not guarantee an individual the most effective means of communication, only the means to communicate effectively. Footnote 17. Members of the City Council, of Los Angeles versus Taxpayers for Vincent. And let's see, that was 2008, California. Appellate. And we have, let's see here. So it's an important thing to see how this is worded and what this means, because it's not just to do a play on words. It's very important the way this is constructed. The First Amendment right does not guarantee an individual the most effective means of communication, only the means communicate effectively. But those means, right, is also protected if it's what they believe to be the most effective means for advocating their cause, not the most effective means of communication. Notice this wording. So if you go in arguing that this is my most effective means of communication, that might not hold. They'll bring up this case. However, if you say, I believe this is the most effective means for me doing so, holding this sign, saying it this way, it might not be the most effective means of communication, but it's something I believe to be the most effective means for doing so, and that would be protected. Important how the intent is explained and communicated. Also, as a general principle, the First Amendment bars the government from dictating what individuals see or read or speak or hear. Wow. And a law imposing criminal penalties on protected speech is a stark example of speech suppression. Footnote 18. State versus Idle, and that's 2008, New Hampshire. So this is a very important statement too, also as a general principle. The First Amendment bars the government from dictating what individuals see or read or speak or hear, and a law imposing criminal penalties on protected speech is a stark example of speech suppression. So even what you read or hear, right, if the government's dictating it, it's an example of speech suppression. The First and 14th Amendments require a measure of protection for advocating lawful means of vindicating legal rights, including advising another that his or her legal rights have been infringed. Footnote 19. And that's Vinluan versus Doyle, 2009, as amended on other grounds, 2009. It's pretty deep stuff here. Now we're on to the practice tip. When the government restricts speech, the government bears the burden of proving the constitutionality of its actions. The fact that a statute does not impose a complete prohibition on certain type of speech, but instead imposes a burden on speech, does not affect the analysis of the statute under the First Amendment. The distinction between laws burdening and laws banning speech is but a matter of degree, and the government's content-based burdens must satisfy the same rigorous scrutiny as its content-based bans. Wow. Burdens and bans. Same rigorous scrutiny. And that is, there we go, U.S. versus Playboy Entertainment Group, 2000. And 20. Okay, yeah, so this practice tip is from that case. Both these footnotes. Same case. And there's 2 points that we get from that. One, is that the government bears a burden of proving the constitutionality of its action when it restricts speech. And the second part we learn from this is the fact that a statute does not impose a complete prohibition on certain type of speech, but imposes a burden on speech. Does not if the statute does not do a complete prohibition on a certain type of speech, but places a burden on that type. It's not a prohibition, but they place a burden, right? It does not affect the analysis of the statute under the First Amendment. So whether they want to ban it or put a burden, it's the same thing under the analysis of the statute. The distinction between laws burdening and banning is but a matter of degree, and the government's content-based burdens must satisfy the same rigorous scrutiny as its content-based bans. Now, this applies heavily to what we're in today, over 2 decades later, a quarter century later almost, and we're seeing this playing out. So there's your cases there. U.S. versus Playboy, Entertainment Group Incorporated, 2000. And we're going on to the next section, section 459, constitutional protection of speech as limited to government abridgment. Let's pop over here to the chat and see if we got to refresh this here. All right, well, if you guys are still here, please hit the like if you haven't already. Make sure that we're getting the word out. Seems like notifications have been a little bit thin lately. Hope it's not on any kind of content-based burden here I'm being imposed. As a general rule, the constitutional guarantee of free speech is a guarantee only against abridgment by the federal or state government, and not by private persons using their property non-discriminatorily for private purposes only. Indeed, purely private restrictions on the right of speech are not prohibited in many instances where the First Amendment would forbid similar interference by the government. The First Amendment, the terms of which apply only to governmental action, ordinarily does not itself throw into constitutional doubt decisions of private citizens to permit or restrict speech, even where those decisions take place within the framework of a regulatory regime, such as broadcasting. Indeed, under the First Amendment's Free Speech Clause, the citizen is entitled to seek out or reject certain ideas or influences without government interference or control. So here we have all the cases here, telecommunications, again our Playboy case from 2000. So as a general rule, we're looking here at limited to government abridgment. Right, is only against abridgment by the federal or state government and not by private persons, using their property non-discriminatorily for private purposes only. And we're on to 460, broad or liberal construction of constitutional right to freedom of speech and press. The First Amendment does not speak equivocally, but prohibits any law abridging the freedom of speech or of the press, and is to be taken as a command of the broadest scope that explicit language, read in the context of a liberty-loving society, will allow. Wow, that's a good one there. Let's see, that's from 1946, Pennycamp versus State of Florida. Wonder if that's the John Pennycamp the park was named after. It was after 46, so it could be. Let's read this again. The First Amendment does not speak equivocally, but prohibits any law abridging the freedom of speech or of the press, and is to be taken as a command of the broadest scope that explicit language, read in the context of a liberty-loving society, will allow, in the broadest scope that explicit language, read in the context of a liberty-loving society, will allow. A broad conception of the First Amendment's guarantee of freedom of speech and of the press is necessary to supply the public need for information and education with respect to the significant issues of the times. On the other hand, the free speech provisions of the First Amendment must be construed as part of a constitution which creates a government for the purpose of performing several very important tasks. And the First Amendment should be interpreted so as not to cripple the regular work of government. That's footnote 3, Columbia Broadcasting versus Democratic National Committee, 1973. And here we are again, 50 years later, running through the same rigmarole. Observation. The decisions of the United States Supreme Court in matters concerning free speech doctrine are entitled to respectful consideration in interpreting a state freedom of speech clause and ought to be followed unless persuasive reasons are presented for interpreting the state clause differently from the First Amendment. Persuasive reasons. Also, dissenting opinions and academic criticism of the United States Supreme Court First Amendment precedent may be sources of persuasive reasons to interpret the state freedom of speech clause differently from the First Amendment. That's footnote 5, 2008, Gallo Cattle Company versus Kawamura, California Appellate. And 4 was the same one. So this is from that case here, this observation. Decisions of the United States Supreme Court in matters concerning free speech doctrine are entitled to respectful consideration in interpreting a state freedom of speech clause that ought to be followed unless dissenting opinions and academic criticism serves freedom of speech differently from the First Amendment. So the dissenting opinions, it seems like. Okay. So that's a good case to research if this seems like a similar case that anyone might be dealing with. And we're on to section 461. Purpose of constitutional guarantees of free speech and press. So what's the purpose of having this guarantee in the first place? If it's not to cripple the government, right, there has to be a purpose. The constitutional right of free expression is intended to remove governmental restraints from the arena of public discussion, putting the decision as to what views can be voiced largely into the hands of each of us, in the belief that no other approach would comport with the premise of individual dignity and choice upon which our political system rests. Wow, individual dignity and individual choice. You know, a liberty-loving society. Free speech serves many ends, as it is essential to the democratic form of government, and it furthers the search for truth. And whenever the federal government or a state prevents individuals from saying what they think on important matters, or compels them to voice ideas with which they disagree, it undermines these ends. That's footnote 2. Janus versus American Federation of State, County, and Municipal Employees. Wow, 2018. The safeguarding of the rights of free speech and of the press to the end that individuals may speak as they think on matters vital to them and that the falsehoods may be exposed through the processes of education and discussion is essential to a free government. So salute to all of you for being here as we express this tonight. The protections afforded by the First Amendment to freedom of speech and of the press are designed to assure an unfettered interchange of ideas for the bringing about of political and social changes desired by the people. And underlying such purpose is a belief that the best test of truth is the power of the thought to get itself accepted in the competition of the market. As we say, argumentation is because not all ideas are equal. It's a way of finding out which ideas are better than others using logic, critical thinking. At the heart of the First Amendment lies the principle that each person should decide for himself or herself the ideas and beliefs deserving of expression, consideration, and adherence. The constitutional right of free expression puts the decision as to what views can be voiced largely into the hands of each person, in the hope that the use of such freedom will ultimately produce a more capable citizenry and a more perfect polity, and in the belief that no other approach would comport the premise of individual dignity and choice upon which the political system rests. The freedom under the First Amendment to think as you will and to speak as you think is a means indispensable to the discovery and spread of political truth, and is essential both to stable government and to political change. That's footnote 7, Independent Newspapers versus Brody in 2009. Wow. Because the effective functioning of a free government depends largely on the force of an informed public opinion, and such informed understanding depends on the freedom of the people to applaud or criticize the way public employees do their jobs, the purpose of the right of free speech guaranteed to every person by the First Amendment to the federal Constitution is to give each citizen the right to criticize public persons and measures. A major purpose of the First Amendment is to protect the free discussion of governmental affairs, including discussions about public officials and candidates for public office, and to foreclose public authorities from assuming a guardianship of the public mind through regulating the press, speech, and religion. Indeed, the right to criticize public officials is clearly protected by the First Amendment. So we get footnotes 8, 9, 10, 11, and 12. So we get Arizona Free Enterprise Club's Freedom Pack, 2011. And then we have Landmark Communications versus Virginia from 78. Bell versus Procunier, 74. We got the Arizona one. And look at this one. Monroe versus Socialist Workers Party in 1986. Cohen versus California, 1971. And Jenkins versus Rock Hill Local District. Is that Rock Hill South? 2008 Sixth Circuit. Okay. The safeguarding of free speech. So let's before we go along, just to fully digest this. This is essentially what a lot of people that purport to be First Amendment auditors are engaged in doing. If that is the case, then their intent should be very clearly apparent under this lens here. They should be thinking about this if they want to really be clear in the law on what they're doing and have the full protection. Right? It's the effective functioning of government, functioning of a free government depends largely on the force of an informed public opinion. And such informed understanding depends on the freedom people have to applaud or criticize the way public employees do their job. So there's your line right there. The understanding, right, of this information, an informed opinion, informed public opinion, and such informed understanding depends on the people to be able to applaud or criticize the way the public employees do their job. So the purpose of the right of free speech guaranteed is to give each citizen the right to criticize public persons and measures. Remember, the applauding doesn't need protection. It's the criticism that does. So the First Amendment is the guarantee. It's the free speech guarantee. It's to give each citizen the right to criticize public persons and measures. Major purpose is to protect the free discussion of governmental affairs. Major purpose, not one of the purposes. A major purpose of the First Amendment is to protect the free discussion of governmental affairs. Indeed, the right to criticize public officials is clearly protected by the First Amendment. The safeguarding of free speech and a free press is a national constitutional policy. Footnote 13, New York Times versus Sullivan, 1964. So that's still standing. And there's a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, not the kind you need a Band-Aid for. The purpose of the constitutional safeguard of the First Amendment is to encourage and nurture uninhibited, robust, and wide open self-expression, particularly in matters of governing importance. This should be essential reading for all those wanting to be First Amendment auditors. This should be the required reading before you sign up. Cases. A major purpose of the First Amendment is to protect the free discussion of governmental affairs. And this is a 2022 case, very current, U.S. Constitutional Amendment 1 in response to Elster, 2022. Good case to look up. And we're on to section 462. Let's pop over here to the chat and see if people are still there. Indeed, governmental affairs is a good one and very important, as today we see that most people are counting on that protection. Okay, 462, nature and principal function of constitutional guarantees of free speech and press. The nature and principal function of free speech under our system of government is to invite dispute, and it may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger, like when you call up those public official servants when they're doing misdeeds. The freedom of speech and of the press are fundamental personal rights and liberties, the exercise of which lies at the foundation of free government by free people. It is only through free debate and free exchange of ideas that the government remains responsive to the will of the people and peaceful change is effected. The right to speak freely has been fashioned to assure the unfettered interchange of ideas for the bringing about of political and social changes desired by the people. The right to free speech is a fundamental personal right and essential to the common quest for truth and the vitality of society as a whole. The constitutional guarantees of freedom of speech and of the press are not for the benefit of the press so much as for the benefit of all the people. Look at this. The constitutional guarantees are not for the press, but for the benefit of all the people. The broadly defined freedom of press assures the maintenance of the American political system and an open society. Freedom of the press is not a private property right, but it is a personal right of each citizen to be informed about the current events on a timely basis. Think about that. Current events on a timely basis. It's a right of each citizen to be informed. In its broadest sense, the phrase freedom of the press includes not only exemption from censorship, but also security against laws enacted by the legislative department of the government or measures resorted to by either of the other branches for the purpose of stifling just criticism or muzzling public opinion. The government may not penalize an individual for robustly exercising his First Amendment rights. Read this. The government may not penalize an individual for robustly exercising his First Amendment rights. Footnote 10. That's McCutcheon versus Federal Election Commission, 2014. That should be an interesting case to read. Such freedoms are constitutionally protected not only against heavy-handed frontal attack, but also from being stifled by a more subtle governmental interference. Wow. Above all else, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. Also, the First Amendment does not permit the government to restrict the speech of some elements of society in order to enhance the relative voice of others. Well, we see this a lot being played out, don't we? Certain party lines get precedent over other opinions. The First Amendment creates an open marketplace in which differing ideas about political, economic, and social issues can compete freely for public acceptance without improper government interference. The First Amendment creates a preserve where the views and beliefs of the individual are made inviolate and gives freedom of the mind the same security as freedom of conscience. At the heart of the First Amendment is the notion that an individual should be free to believe as he or she will, and that in a free society, one's beliefs should be shaped by his or her mind and conscience rather than coerced by the state. Freedom of belief is no incidental or secondary aspect of the First Amendment's protections. Wow. So we had footnote 7, State Rel versus Miami Herald Publishing, 1976. Wow, that's an old one there. And Florida. Freedom of the press is not a private property right, but a personal right of each citizen to be informed about current events on a timely basis. 1976. All right. And footnote 12 is generally as to the contents of utterances. Oh, okay. See sections 458. And overruled on other grounds. This is the Janus 2018. So that's a very powerful section here. Again, this is section 462, the nature and principal function of constitutional guarantees of free press, free speech, and press. Now we're on section 463. Conflict of constitutional right to free speech and press with the right of privacy. Now, this is another aspect where we see a lot of conflicts and controversy regarding, and hopefully we can clarify some of the ways that the law affects it here. The rights guaranteed by the First Amendment do not require total abrogation of the right to privacy, inasmuch as there is no constitutional right to force speech into the home of an unwilling listener. According to a state bar's interest in protecting the privacy and tranquility of personal injury victims and their loved ones against intrusive, unsolicited contact by lawyers, has been deemed a substantial interest for purposes of a Central Hudson intermediate scrutiny of state bar rules which prohibited lawyers from sending targeted direct mail solicitations to victims and their relatives for 30 days following an accident or disaster, or accepting referrals obtained in violation of that prohibition. What the heck is this? Central Hudson 3. Central Hudson Gas, 1980, okay, versus Public Service Commission. As to intermediate scrutiny, you see under the Central Hudson holding. Central Hudson. All right, so lawyers and personal injury victims and solicitations is what that seems to be centered around. Despite the constitutional guarantee of freedom of expression, The government may properly act in many situations to prohibit intrusion into the privacy of the home of unwelcome views and ideas which cannot be totally banned from the public dialogue. Nothing in the United States Constitution compels a person to listen to or view any unwanted communication, whatever its merit, and no one has a right to press even good ideas on an unwilling recipient. A statute authorizing a householder to require his or her name be removed from the mailing list of a mailer pandering advertisements, and that all future mailings to the householder should cease, does not violate the First Amendment. A mailer's right to communicate must stop at the mailbox of an unreceptive addressee. Footnote 7. Rowan versus U.S. Postal Department. U.S. Post Office Department, 1970. It's no longer called that. It's the United States Postal Service now. So I wonder how that would affect this holding. Perhaps just the case itself, not the parties. That it wouldn't probably matter. Once again, a mailer's right to communicate must stop at the mailbox of an unreceptive addressee. So they keep mailing after you said stop it, then they must stop. On the other hand, the availability of government to shut off disclosure solely to protect others from hearing it is dependent on showing that substantial privacy interests are being invaded, in that an essential intolerable and are being invaded in an essentially intolerable manner. While a state or municipality may protect individual privacy by enacting reasonable time, place, and manner regulations applicable to all speech, irrespective of content, nevertheless, when the government, acting as censor, undertakes selectively to shield the public from some kinds of speech on the ground that they are more offensive than others, the First Amendment strictly limits its powers. Selective restrictions are valid only when the speaker intrudes on the privacy of the home, or the degree of captivity makes it impractical for the unwilling viewer or auditor to avoid exposure. Of course, auditor is the one who hears in this context, I believe. Viewer or auditor, view or hear. The mere presumed presence of unwitting listeners or viewers does not serve automatically to justify curtailing all speech capable of giving offense. The determination of issues pitting the First Amendment rights of speakers against the privacy rights of those who may be unwilling viewers or auditors remains delicate balancing because, in the sphere of collision between claims of privacy and those of free speech, the interests on both sides are plainly rooted in the traditions and significant concerns of the American society. So again, reasonableness and such always comes down to what society is prepared to accept. Briscoe versus Reader's Digest. Is that even still around? Overruled on other grounds. That was 1971, of course. Then we have Gates versus Discovery Communication in 2004. That was on footnote 1, which is the rights guaranteed by the First Amendment do not require total abrogation of the right to privacy. So, as we can see, this is some well-established cases on this, a lot of ongoing litigation. Back to our Central Hudson holding. Snyder versus Phelps, 2011. Yeah, we have a few 75. So yeah, it's all over the place here. 71. It looked like a lot of activity was going on in the early 70s regarding freedom of speech. Remember Watergate and all that. And we're on to section 464, the scope of constitutional guarantee of free speech and press generally. So the scope of the constitutional guarantee. We'll see how much we have that guarantee. And before we do that, let's jump over here to chat, refresh chat. Chat's a little thin tonight. I hope everyone was able to get notifications. I didn't see them come out, but I know some people are here, so let's just continue. So we're on to section 464, the scope. If there is a bedrock principle underlying the scope of the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Now let's look how this contrasts with what we just said here. The interests of both sides are plainly rooted in tradition's significant concerns. So collision between privacy and free speech, scenes where we have a controversy or a collision with American society. And now taking that into context with our next section, if there is a bedrock principle underlying the scope of the First Amendment, is that the government may not prohibit the expression of an idea, bedrock principle, simply because society finds the idea itself offensive or disagreeable. In public debate, insulting and even outrageous speech must be tolerated in order to provide adequate breathing space to the freedoms protected by the First Amendment. Freedom of speech and of the press rests on the assumption that the widest possible dissemination of information from diverse and antagonistic sources is essential to the welfare of the public. The underlying safeguard of the constitutional provision for freedom of the press or of speech is that opinion is free and conduct alone is amenable to the law. However, to be sufficiently imbued with communicative elements warranting constitutional protection under the Free Speech Clause, an activity need not necessarily embody a narrow, succinctly articulable message, but the reviewing court must find, at the very least, an intent to convey a particularized message, along with a great likelihood that the message will be understood by those viewing it. Wow. To be sufficiently imbued with communicative elements warranting constitutional protection, an activity need not necessarily embody a narrow, succinctly articulable message, right? So it could be in various ways, but it must find at the very least an intent to convey a particularized message along with a great likelihood. So here's your preponderance here, a great likelihood that the message will be understood by those viewing it. That's footnote 5, 2003, Zalewski versus County of Sullivan, New York. Okay. As long as the means are peaceful, the communication need not meet standards of acceptability in order to be protected by the constitutional guarantee of freedom of expression. Since the government may not regulate speech based on its substantive content or the message it conveys, nor may it, in the realm of private speech or expression, favor one speaker over another, inasmuch as any discrimination against speech because of its message is presumed to be unconstitutional. So there's your presumption. Footnote 7, Rosenberger versus Rector and Visitors of University of Virginia, 1995. Oh, talk about unwelcome guests. The First Amendment generally prevents the government from proscribing speech or even expressive conduct because of its disapproval of the ideas being expressed. Indeed, as a general matter, the First Amendment means that the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. However, this principle, like other First Amendment principles, is not absolute, and few things are. Footnote 9, Ashcroft versus ACLU, 2002. The First Amendment generally prohibits the government from enacting laws that abridge the freedom of speech because of disapproval of its content. While the government may consistently with the First Amendment advocate in favor of its own policies, it may not suppress opposing views. So the government can, toot its own horn, but it cannot suppress opposing views. Footnote 11. Page versus Lexington County School District in 2008. The First Amendment recognizes that a certain amount of expressive disorder is not only inevitable in a society committed to individual freedom, but also must itself be protected if that freedom would survive. However, the right of free speech does not encompass the right to cause disruption, and that is particularly true when those claiming the protection of the First Amendment cause actual disruption of an event covered by a permit. Footnote 13. Startzel versus City of Philadelphia, 2008. Moreover, the First Amendment does not protect conduct that intentionally obstructs government or operations. Also, the First Amendment does not protect illegal conduct implemented through trade associations. Under the First Amendment, the public has the right to every individual's views, and every person has the right to speak them, without regard to whether the persons involved are famous or anonymous. The First Amendment's basic guarantee is that of freedom to advocate ideas, and the freedom to engage in association for the advancement of beliefs and ideas is an inseparable aspect of the freedom of speech. Moreover, the rights of free speech and free press, although not identical, are inseparably connected with the rights to assemble peaceably and to petition for a redress of grievances, all of which rights are among the most precious of the liberties safeguarded by the Bill of Rights. That's footnote 20. United Mine Workers of America versus the Illinois State Bars Association, 1967. Wow. The statutory prohibition against providing material support or resources to a foreign terrorist organization does not violate the First Amendment's guarantees of freedom of speech and association, since the statute controls conduct rather than communication. See, statutory prohibition. Right, because we know we even have statutes at large that prohibit those things. Practice tip. The general rule that the plaintiff must assert his or her own legal rights and interests cannot rest his or her claim to relief on the legal rights or interests of third parties. It's relaxed in the First Amendment context, where there is danger of chilling free speech. Society's interest in having a statute challenged may outweigh prudential considerations that normally counsel against third party standing. Wow. So, in the First Amendment context, third party standing is relaxed. It may have better chances of it because of the chilling free speech aspects, the danger of that. Nice. Let's see, that was footnote 22. And that's Mothershed versus Justices of Supreme Court as amended on other grounds. Wow, opinion amended on grounds 2005. Wow, so from a third party. And of course, this one here, the statutory prohibition, of course, was against this here, footnote 19, or 21, I'm sorry, is the People's Mohad. Oh, geez. All right. We're on to section 465, subject of speech protected. Speech by citizens on matters of public concern lies at the heart of the First Amendment, which was fashioned to assure unfettered interchange of ideas for bringing about of political and social changes desired by the people. The First Amendment creates a forum in which all may seek, without hindrance or aid from the state, to move public opinion and achieve their political goals. Speech is protected even when the subject or manner of expression is uncomfortable. Oh, you're making me uncomfortable. People are feeling uncomfortable. Well, speech is protected even when the subject or manner of expression is uncomfortable. That's footnote 3. And that is Operation Rescue National versus Planned Parenthood. 98. Okay. The right to free speech allows for an uninhibited, robust, and wide open discussion of public issues that may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Footnote 4. GD versus Kenny, 2011. Moreover, the First Amendment denies a state the power to prohibit dissemination of social, economic, and political doctrine which a vast majority of its citizens believe to be false and fraught with evil consequence. Footnote 5. That's Rodriguez versus State in Florida. Wow, 2004. Humor is a protected form of free speech, just as much to be given full scope under appropriate circumstances as the political speech, the journalistic expose, or the religious tract. Rhetoric, hyperbole, and expressions of opinion not asserting actual or provable facts are protected speech. Rhetorical hyperbole. I like that. New Times, yeah, they're pretty good on the rhetorical hyperbole, stating that the First Amendment does not police bad taste. Anyone familiar with that publication? They are masters of bad taste. Although they will have some good articles from time to time, but that's going back decades. All right, so humor. The right to freedom of speech and of the press under the First and 14th Amendments is as extensive with respect to discussion related to matters of local concern as to matters of federal concern. It protects speech and assembly regarding secular as well as political causes, and the rights of free speech and free press protected thereby are not confined to any particular field of human interest. These rights extend to myriad matters of public interest or concern, embracing all issues about which information is needed or appropriate to enable members of society to cope with the exigencies of their period. The First Amendment assures the broadest colorable exercise of free speech and free press for religious, political, economic, scientific, news, or informational ends, insomuch as the Constitution's basic guarantee of freedom to advocate ideas is not confined to the expression of ideas which are conventional or shared by a majority. Freedom of speech is of paramount importance and may not be denied merely because it may create dispute. Get that? Paramount importance may not be denied merely because it may create dispute. You're disturbing people. Hence, the dissemination of various views may not be suppressed because they are unpopular, extreme, or controversial, distasteful, defiant, or contemptuous, offensive to some hearers or viewers, or foolish and irresponsible. This is so, irrespective of the truth of the utterances. For example, speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of the Supreme Court's free speech jurisprudence is that it protects the freedom to express hated thoughts. However, unwanted speech that threatens, alarms, harasses, or annoys an individual may be prescribed without violating the speaker's right to free expression. The guarantee of the First Amendment protects expression which is eloquent no less than which it is unconvincing. So you don't have to be eloquent nor convincing. In the realm of protected speech, a state legislature is constitutionally disqualified from dictating the subjects about which a person may speak and the speakers who may address a public issue. The government may not prohibit the dissemination of ideas that it disfavors, nor compel the endorsement of ideas that it approves. Consistent with this, government now prohibit dissemination of ideas that it disfavors, nor compel the endorsement of ideas that it approves. Boy, they do that a lot, though. That's footnote 25. That's got to be old. 2012, yeah, that all changed. Consistent with this, the state may not burden the speech of others in order to tilt public debate in a preferred direction. I guess American jurisprudence is engaged in a little of that First Amendment humor here. Sorrell versus IMS Health Incorporated, 2011. So it says the state may not burden the speech of others in order to tilt public debate in a preferred direction. Interesting. Indeed, laws designed or intended to suppress or restrict the expression of specific speakers contradict basic First Amendment principles. The constitutional protection is not limited to the exposition of ideas, and the protection afforded to free speech extends to speech or publications which are entertaining, as well as to those which are instructive or informative. Under the First Amendment Free Speech Clause, once the government has chosen to permit discussion of certain subject matters, it may not then silence speakers who address those subject matters from a particular perspective. There's our word particular again. The First Amendment right to obtain legal advice does not depend on the purpose for which the advice is sought, and the First Amendment protects the right of an individual or group to consult with an attorney on any legal matter. Full disclaimer, American Jurisprudence and Westlaw is written by attorneys. This right applies equally to legal representation intended to advocate a political or social belief or to recover damages in a personal injury suit. Footnote 32. All right. Denius versus Dunlop in 2000. The filing of an equal opportunity employment commission complaint constitutes protected speech. And that's footnote 33. Jones versus City of Wilmington, and that was Delaware, 2004. Okay, so that kind of sums up the subject of speech protected. As you can see here, myriad of matters of public interest that's appropriate to enable members of society cope with the exigencies of their period. Pretty good language there. Footnote 11. Of course, that's 1978. First National Bank of Boston versus Bellotti. And we're on to section 466, the medium of speech protected. For the purpose of First Amendment analysis, the Constitution protects more than the written or spoken words as media of expression, and instead includes, are you ready? Pictures, films, paintings, drawings, and engravings, as well as music, theater, and DVD recordings. Whatever the challenges of applying the Constitution to ever-advancing technology, basic principles of freedom of speech and press, like the First Amendment's command, do not vary when new and different medium for communication appears. Wow, let's look at the years on these. 2008, 2011, DVDs. What's a DVD? And then we're on to section 467, the First Amendment protection of private speech. And before we get to this, let's check over to the chat. Welcome to Bill Thomas. Yeah, restrictions on free speech should cause the smallest burden necessary to achieve a compelling governmental interest, or a public interest. Really, it's for the public. Restrictions should be narrowly tailored to restrict only what is essential to achieve the compelling interest of the state. Nature of the form where the speech may allow for more restrictions. Those valid restrictions are content neutral. Right, and what we're trying to get here is the substance of where these challenges come from, and if future ones come up that don't apply, as broadly as some of those references there. We want to be able to see deeply where the principles lie and where remedy may also lie for anyone that has had this right infringed on. So we're on section 467, the First Amendment protection of private speech. Not all speech is of equal First Amendment importance, and where matters of purely private significance are at issue, purely private, First Amendment protections are often less rigorous because restricting speech on purely private matters does not implicate the same constitutional concerns as limiting speech on matters of public interest. There is no threat to the free and robust debate of public issues. There is no potential interference with a meaningful dialogue of ideas, and the threat of liability does not pose the risk of a reaction of self-censorship on matters of public import. However, when a unit of government creates a limited public forum for private speech in either a literal or metaphysical sense, wow, some content-based and speaker-based restrictions may be allowed, but even in such cases, viewpoint discrimination is forbidden. So here's the first time I've actually seen this term in any kind of legal context, limited public forum. And luckily we have footnote 2 to follow up on for that. And that's Mattel versus Tam, 2017. So this is rather recent. And back here with the Snyder versus Felt from 2011, which is footnote 1. Threat of liability does not pose a reaction of self-censorship on matters of public import. So there's that chilling effect again. And limited public forum. For further research, here's our case, Mattel versus Tam. And that's in Connecticut, and that was 2017. You have to look up this and find out what the actual text is and how they come up with this limited public forum for private speech in metaphysical sense. So there should be an interesting terminology in that case. And now we're on section 468, the regulations based on speaker's viewpoint or content of speech. Oh boy, content and viewpoint. When enforcing the First Amendment's prohibition of laws that abridge the freedom of speech, the court distinguishes between content-based regulations, which target speech based on its communicative content, and content-neutral regulations of speech. So we have the content-neutral regulations and content-based regulations. Governmental regulation of speech is content-based and presumptively unconstitutional if a law applies to a particular speech, remember, back to particulars, because of the topic discussed or the idea or message expressed. And this common sense meaning of the phrase content-based requires a court to consider whether a regulation of speech on its face draws distinctions based on the message a speaker conveys. Wow. So whether the regulation of the speech on its face draws distinctions based on the message. Wow. That's footnote 3. We're going to get into this deeper, it looks like. So they're giving it to us in the broad sense here. 2015. All right, let's go in deep now. A constitutionally permissible time, place, or manner restriction on speech may not be based on either the content or the subject matter of the speech. So depending what you're saying cannot affect the time, place, or manner restriction. Because the vagueness of content-based regulation of speech raises special First Amendment concerns in view of its obvious chilling effect on free speech. Indeed. The First Amendment prohibits a government from discriminating based on a viewpoint that the speaker seeks to express, regardless of the nature of the forum. Viewpoint discrimination as an egregious form of content discrimination, and therefore the government must abstain from regulating speech when a specific motivating ideology or opinion or perspective of the speaker is the rationale for the restriction. Viewpoint discrimination is censorship in its purest form, and government regulation that discriminates among viewpoints threatens the continued vitality of free speech. Viewpoint-based restrictions violate the First Amendment, regardless of whether they also serve some valid time, place, and manner interest. So they override these time, place, and manner interests when they're viewpoint restrictions. That's invalid. When the government seeks to restrict speech based on its content, the usual presumption of constitutionality afforded congressional enactments is reversed. Content-based regulations are presumptively invalid under the First Amendment, and the government bears the burden of rebutting that presumption. The rationale of the general prohibition against content-based regulations of speech is that content discrimination raises the specter that government may effectively drive certain ideas or viewpoints from the marketplace. Footnote 14. That's Davenport versus Washington Educational Association, 2007. Wow. Good one there. Here's our observation now. When someone challenges a law as viewpoint discriminatory, but it is not clear from the face of the law which speakers will be allowed to speak. The plaintiff, he must show that he was prevented from speaking, while someone espousing another viewpoint was permitted to do so. There you go. That's footnote 15. See where that happened. See McCullen versus Coakley, 2014, Connecticut. All right. The fear that speech might preclude or that people would make bad decisions if given truthful information cannot justify content-based burdens on speech. Wow, the fear that speech might persuade or that people would make bad decisions if given truthful information cannot justify content-based burdens on speech. Wow, truthful information. 16. That's Terrell versus IMS Health again, 2011. Wow, I wonder what that's all about. Premised on mistrust of governmental power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints, and prohibited too are restrictions distinguishing among different speakers, allowing speech by some but not others. In administering a public forum, the government may not permit speech that expresses one viewpoint while prohibiting speech expressing the opposite viewpoint. The government has no authority to license one side of a debate to fight freestyle while forbidding the other to fight at all. Oh my gosh, this is a good one here. In administering a public forum, the government may not permit speech that expresses one viewpoint while prohibiting speech expressing the opposite viewpoint. The government has no authority to license one side of a debate to fight freestyle while forbidding the other to fight at all. Wow, wonder where that was. 18, footnote 18. And that's Grossbaum versus Indianapolis-Marion County Building Authority, 1996, and Mahoney versus Babbitt in D.C. Circuit, 97. But those are some colorful cases. The First Amendment's hostility to content-based regulation extends not only to restrictions on particular viewpoint, but also to a prohibition of public discussion about an entire topic, in as much as allowing a government the choice of permissible subjects for public debate would be to allow government to control over the search for political truth. Yikes. Before exempting a category of speech from the normal prohibition on content-based restrictions, the Supreme Court must be presented with persuasive evidence that a novel restriction on content is part of a long, if heretofore unrecognized, tradition of proscription. Without persuasive evidence that a novel restriction on content, the legislature may not revise the judgment of the American people. Let's read this one more time. Without the persuasive evidence that a novel restriction on content is part of a long, if heretofore unrecognized, long tradition of proscription, The legislature may not revise the judgment of the American people, embodied in the First Amendment, that the benefits of the amendment's restrictions on government outweigh the costs. However, that's footnote 22. I wonder what that could be. Brown versus Entertainment Merchants Association, 2011. Wow. Rather current. However, when totally proscribable speech is at issue, content-based regulation is permissible as long as there is no realistic probability that official suppression of ideas is afoot. Content discrimination among various instances of a class of proscribable speech does not pose a threat to the marketplace of ideas when the selected subclass is chosen for the very reason the entire class can be proscribed. All right, it says 24. Say same one here, 20. Davenport versus Washington Education Association, 27. All right, so this one here is getting into the content-based regulations and subclasses and classes, in that there's certain proscribable speech that doesn't pose a threat, but it has to be applied widely, not particularly to a subclass. The First Amendment does not forbid viewpoint-neutral exclusion of speakers who would disrupt a non-public forum and hinder its effectiveness for its intended purpose. However, the existence of reasonable grounds for limiting access to a non-public forum will not save a regulation that is in reality a facade for viewpoint-based discrimination. Now, that's in a private forum, right? A non-public forum, which I guess could be in a limited public forum. Footnote 25, and that is Cornelius versus NAACP Legal Defense and Educational Fund, 1985, and Jacobson versus Howard, 97. It's pretty deep stuff here. And who thought First Amendment auditing was straightforward and simple? As you see here, we're getting pretty deep into First Amendment, and to audit something like this, you really have to know its foundational principles deeply to be able to find out where there's any kind of nonconformities in the practice of these laws. All right, a First Amendment challenge to a statute may also be based on the fact that it abridges too little speech. Under inclusivity in regulating speech creates a First Amendment concern when the state regulates one aspect of a problem while declining to regulate a different aspect of the problem that affects its stated interest in a comparable way. Under inclusivity, that's footnote 27. That's Williams-Yulee versus Florida Bar, 2015. And boy, we're going to read a lot from that one. And then we'll get back to the Playboy case. We also have the city of Granite City, Illinois. All right, so we'll find out about these shortly. Let's see here. Oops, passed it up, didn't I? All right. First Amendment challenge to a statute may also be based on the fact that it abridges too little speech. So that's our under inclusivity, right? Well, it's always somewhat counterintuitive to argue that a law violates the First Amendment by abridging too little speech. Under inclusiveness can raise doubts about whether the government is in fact pursuing the interests it invokes, rather than disfavoring a particular speaker or viewpoint. Or under inclusiveness can reveal that a law does not actually advance a compelling interest. Nice. However, the First Amendment imposes no freestanding under-inclusiveness limitation, and a state need not address all aspects of a problem in one fell swoop. Policymakers may focus on their most pressing concerns. Wow. Under-inclusivity. Where a state regulates speech based on its content, it must be narrowly tailored to promote a compelling government interest. And if a less restrictive alternative would serve the government's purpose, the legislator must use that alternative. An adequate alternative channel of communication required for speech restriction to survive constitutional scrutiny does not have to be the speaker's first or best choice, or one that provides the same audience or impact for the speech, but the alternative must be more than merely theoretically available. It must be realistic as well. An alternative channel of communication required for speech restriction to survive constitutional scrutiny is not realistic when it requires a speaker significantly and perhaps prohibitively more time to reach the same audience. Where a plausible, less restrictive alternative is offered to a content-based speech restriction, it is the government's obligation to prove that the alternative will be ineffective to achieve its goals. Where the design benefit of content-based restriction is to shield sensibilities of listeners, the general rule is that the right of expression prevails, even where no less restrictive alternative exists. On to our cumulative supplement here. The cases simply pointing to a handful of instances of allegedly inconsistent enforcement, pattern practice, right? A handful of instances is not enough to justify declaring a statute unconstitutional under the First Amendment as applied to conduct the parties do not dispute falls under its purview. In such circumstances, there is neither a pattern of enforcement activity based on content or viewpoint, nor a showing of government intent underlying the disparate application. So that's Frederick Douglass Association Incorporated, 2021, a very recent case. So keep in mind now, this is how the courts are currently looking at these things. Inconsistent enforcement, alleged inconsistent enforcement is not enough to justify declaring a statute unconstitutional. Okay, remember, we're looking for a pattern of enforcement based on content that would show an underlying intent or disparate application. So a handful of instances, they need to correlate in a way that would provide a legal nexus, it seems, of showing that governmental intent. Okay, important things for keeping records and not just grabbing hodgepodge inconsistent or unrelated events that just happen to be similar. Not saying that it doesn't mean there's wrongdoing. That still would bring about suspicion. But as far as constructing a case, it would have to be. Seems the way the courts are ruling now, it would have to be done better than that. Let's see. What footnote was that? Well, that wasn't a footnote. That was our supplement. That was a pretty comprehensive section. And it takes section 469. We're almost done here. Regulations based on speakers' viewpoints or contents of speech, particular content-based regulations. All right, let's follow this. This is fun stuff here. So those of you that have stayed this long should be able to get into this. And before we do that, let's check with the chat, see lucky winners that are still here. Let's see here. Where are we here? Wow. Okay, I really need to refresh this thing here. Looks like I lost a lot of stuff. Okay, there we go. This is good notice for bootleggers. All right, laws that try to restrict appeals for charitable donations, panhandling, have been found to violate. Yeah, as in Florida, we have the great Honor Your Oath, Jeff Gray, who has been really at the forefront of doing this. I think he's probably done more as far as what we're speaking about here than any other First Amendment auditor out there. And urging people to resist the draft in time of war was found outside. Yeah. Some of these cases we have from the 70s were probably might have had some relics of that in them. I think a private office of an official counts as a non-public forum, but the lobby outside might be limited. Yeah, I mean, some of these things are not necessarily statutory or even or law, but are decided by precedent, and they just hold up other ones of that. Yeah, strict scrutiny. That's what we're under here. We need to keep everyone under strict scrutiny. So here we go. In consonance with the principles generally prescribing regulations based on a speaker's viewpoint or the content of the speech, the courts have held that, here we go, the Stolen Valor Act's prohibition on false claims of receipt of military decorations or medals constitutes a content-based restriction of free speech in violation. Wow. So stolen valor isn't a statute anymore, huh? U.S. versus Alvarez, 2012. A statute criminalizing the commercial creation, sale, possession of depictions of animal cruelty regulates an expression based on content. And the statute is presumptively invalid under the First Amendment, as the statute restricts visual and auditory depictions, such as photographs, videos, or sound recordings, depending on whether they depict conduct in which a living animal was intentionally harmed. Ooh, 3, and that's U.S. versus Stevens, 2010. Nice current cases here. A regulation prohibiting local recipients of legal services corporation funds from engaging in representation involving an effort to amend or otherwise challenge the validity of existing welfare laws is impermissible viewpoint discrimination and violation. The provisions of federal statute prohibiting transmission of obscene or indecent communications over the internet to persons sending this are unconstitutional. A statutory provision prohibiting signs or displays critical of foreign investments within 500 feet of their embassies, although not viewpoint-based, is content-based restriction that is not narrowly tailored to serving a compelling state interest and violates the First Amendment. Well, here we go. Here's my favorite one. A heckler's veto is an impermissible content-based restriction on speech, where that speech is prohibited due to an anticipated disorderly or violent reaction of the audience. The heckler's veto is unconstitutional, guys. A state statute prohibiting the release of the residential address, phone number, and other personal information of law enforcement officers and court employees with intent to harm or intimidate is deemed to be content-based for First Amendment purposes, since the statute prohibited truthful, lawfully obtained, publicly available personal identifying information based solely on whether the information is identified. Okay, so footnote 8. For those of you that want to release that information, they say you can't. There it is. It's Sheehan versus Gregory, and that's in Washington, 2003. Now, on the other hand, courts have held that a Federal Trade Commission ruling that an automated telephone services provider furnished a 2-second connection to a sales representative when a call generated by a telemarketer is answered is not a content-based restriction on barred by the First Amendment, which apply to calls by the provider at the direction of charity. Since the government has a legitimate interest in limiting nuisance calls to telephone subscribers, the interest is furthered by narrowly tailored restriction, and there was no appreciable limitation on charitable solicitations, as the restriction was minimal, and charities could solicit directly. So they had alternative methods. So that meant that automated had to furnish this stuff. Okay, so again, we're back to what we read earlier, and now we see the case, footnote 9 here. And that was 2006 in the Middle District of Florida, the broadcast team, jeez, versus the FTC, the broadcast team. Oh, gosh. All right, where are we here? Statute providing persons from standing in the traveled portion of a roadway for the purpose of soliciting a ride, enjoyment, or business from vehicle occupants, which precluded news vendors from standing in the roadway to sell newspapers to passing motorists. Read all about it. Is not impermissibly content-based, even though it does not burden all communication potentially disruptive to traffic, such as politically campaigning, absent any evidence, and the state disregard with the viewpoints with the forbidden categories. So it's saying that, let's see, because the way they use double, triple, quadruple negatives in here, you can get confused easily. So let's break it down. The statute prohibiting persons, right, is not impermissibly content-based. Not so it is allowed, even though it does not burden all. So I guess it's because they have other methods of doing it too. And that's newspaper. That's the old Sun Sentinel, City of Hollywood, 2003. So that's rather current. Well, I don't see them in the roadway, so I guess that worked with the courts. All the better, um, as there are better channels for getting newspapers. And what's a newspaper, anyways? And we're on Section 470, guarantees of free speech and press as protecting publication, as we were just speaking of, distribution and receipt of material. So, once again, and let's check over here to the chat real quick. Deliberate exaggeration in advertising is called puffery and is especially excluded from laws against false advertising. Yeah, as we saw there, hyperbole and comedy is allowed. Yeah, I am not convinced that many of the restrictions on commercial speech are valid. Probably not. Yeah, no, Bill Thomas, none of this is excessive. As you can see, we're pretty slim on the comments, so you're making up for the lack of others commenting. So it's welcome. So now, once again, yeah, this is an important topic. I think this is one that people have always taken very lightly, and look how deep we've gone into this. I mean, just the time alone we spent here is probably one of the longer live streams. We're almost up to the 2-hour mark. So this tells you how deep the First Amendment of freedom of speech and of the press really goes, and how little most people know that are out there supposedly auditing and checking on this. This is essential knowledge here before anyone goes out into the field, I believe, to try to enforce any of this. Other than that, we should be the recipients of free information and having the ability to choose what to believe. The constitutional guarantee of freedom of speech and of the press embraces the distribution or circulation of speech and also protects the publication of and necessarily protects the right to receive and read or to see and hear the matter being distributed or broadcast. The freedom of speech under the First Amendment is not merely the freedom to speak, but is also the freedom to read. Wow. Moreover, while the First Amendment protects not only the right to engage in protected speech, but also the right to receive such speech, the rights of the recipients of speech are derived in the first instance from the primary rights of the speaker. So derivative rights. Wow. Observation, the regulation of the government by the radio and television broadcast industry. Wow, the regulation by the government of the radio and television broadcast industry presents a particular concern with regard to the means of distribution of protected speech, where some degree of governmental control must be tolerated for the broadcast of speech to be effective. The Supreme Court has developed an intermediate scrutiny standard, under which, for First Amendment free speech purposes, the government may employ a means of its own choosing, as long as the regulation promotes a substantial governmental interest that would be achieved less effectively absent the regulation, and does not burden substantially more speech than is necessary to further that interest. Does not burden any more than to fulfill that interest, to further that interest. That's footnote 9. Let's look at this. Turner Broadcasting 97 versus FCC. Good old Ted Turner. All right, and then we're on to liberty. In circulating one's speech is as essential to the freedom as is the liberty of publishing, since publication without circulation would be of little value. The freedom of speech is indispensable to the discovery and spread of political truth, and the best test of truth is the power of the thought to get itself accepted in the competition of the market. Liberty in circulating one's speech is essential to the freedom, as is the liberty of publishing, since publication without circulation would be of little value. And this is a great statement. Once again, the freedom of speech is indispensable to the discovery and spread of political truth. And the best test of truth is the power of the thought to get itself accepted in the competition of the market. The best test of truth. Not the only, but the best. The freedom of speech and of the press assured by state and federal constitutions are as much infringed by an improper interference with distribution as by an improper interference with publication. The courts have ever been alert to strike down any infringement or limitation upon the fundamental right to freely publish and distribute news and comments. The highest form of state interest must be involved in order to sustain the validity under the First Amendment of a statute imposing a penal sanction for the publication of lawfully obtained truthful information. When a state attempts to punish publication after the event, it must demonstrate that its punitive action is necessary for the state interest asserted. Where a rape victim was brought suit against a newspaper for publishing her name, which it obtained from a publicly released police report, the state courts awarded the rape victim compensatory and punitive damages, and the newspaper appealed. The Supreme Court held that the imposing damages on the newspaper violated the First Amendment, since the information was lawfully obtained and the identification of the victim was accurate, imposing the liability did not serve to further a state interest of the highest order. Although distribution of information is constitutionally protected, still, the peace, good order, and comfort of the community may imperatively require some regulation of the time, place, and manner thereof. And the enforcement of general laws against the press is not, under the First Amendment, subject to stricter scrutiny than would be applied to enforcement against other persons or organizations. So let's see here. That was footnote 15. The Florida Star, great. 1989. Another reputable publication. But, that's part of the deal. So we got Bantam Books versus Sullivan, Board of Education, Island Trees Union Free School District, 1982. Handing out leaflets in the advocacy of a politically controversial viewpoint is the essence of the First Amendment expression. No form of speech is entitled to greater constitutional protection. That's 2014. Handing out leaflets in the advocacy of a politically controversial viewpoint. Nice. And the constitutional protection of speech as extending to silence. The right not to speak. The right not to speak inheres in political and commercial speech alike and extends the statements of facts as well as statements of opinion. The difference between compelled speech and compelled silence is without constitutional significance in the context of protected speech, as the First Amendment guarantees freedom of speech, a term necessarily comprising the decision of both what to say and what not to say. And that's from 1988, Riley versus National Federation of the Blind of North Carolina. Wow. The First Amendment protects against government infringement on the right to speak freely and the right to refrain from speaking at all. The right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. Indeed, there are numerous cases supporting the view that the First Amendment protects the right of persons to refrain from speaking. And that's a First Amendment right, not Fifth. And that's footnote 5. Yep, it's the Riley case. Now let's look at our observation here. One important manifestation of the principle of free speech is that one who chooses to speak may also decide what to say and what not to say. Indeed, a speaker has a right under the First Amendment to be free from state interference and has the autonomy to choose what not to say. Moreover, the right to speak does not carry with it a duty on the part of the hearer to listen. a hearer is entitled to the same protection of his or her rights as a speaker. Nice. And that's all these cases here. Oh, Lord. Okay. Yeah. Boston. Okay. We're on section 472, constitutional protection of speech as prohibiting compelled or coerced speech, compelling subsidized speech of others. Oh boy. If there's any fixed star in the constitutional constellation, it is that no official, high or petty, can describe what is orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess, by word or act, their faith therein, and compelling individuals to mouth support for views they find objectionable, violates that cardinal constitutional command. Regulations which compel ideological speech pose the inherent risk that the government seeks not to advance a legitimate regulatory goal, but to suppress unpopular ideas or information, or manipulate the public debate through coercion rather than persuasion. The First Amendment protects persons from being compelled to express adherence to an ideological point of view which they find unacceptable. There is also authority holding that the First Amendment's proscription of compelled speech does not turn the ideological content of the message that the speaker is being forced to carry. The constitutional harm, what the First Amendment prohibits, is being forced to speak rather than to remain silent. The First Amendment's right to freedom of speech protects an individual's right not to participate in a flag salute or a pledge of allegiance to the United States flag. Newspaper editors or publishers have also been held to have a First Amendment right, under the guarantee of freedom of the press, to refuse to print a political advertisement in exercise of its editorial control and judgment. Wow. Observation. For purposes of free speech clause, simple obedience to a law that does not require one to convey a verbal or symbolic message cannot reasonably be seen as a statement of support for the law or its purpose. So acquiescence, that's footnote 7. Let's see what that is. North Coast Women's Care Medical Group versus Superior Court, California, 2008. Nice. Okay. Okay, we'll skip that one there so we don't get banned on this one here. I'll leave it there for you guys to read. And then observation. Regulations of the Department of Health and Human Services prohibits recipients of funds under Title 10 of the Public Health and Services Act from engaging in abortion counseling, referral, and activities advocating it as a method of family planning, do not violate the First Amendment's condition of the receipt of a benefit Title 10 funding on relinquishment of the First Amendment right to engage in their advocacy and counseling. Such regulations do not force any Title 10 grantee or its employees to give up their speech. They merely require that such activities be kept separate and distinct from activities of the Title 10 project. Okay. Technicalities. The compelled speech rights of middle and high school students are deemed not violated by the school district's request they complete a survey regarding their private lives for use in planning community youth activities, even if the completion is involuntary. Wow. Where the surveys are anonymous and results are only released in aggregate form. A federal statute known as the Solomon Act, which requires law schools to offer military recruiters the same access to its campuses and students that it provides to non-military recruiters, receiving the most favorable access in order for the school and its universities to receive federal funding, does not compel schools to speak the government's message as would implicate. Okay, it's compelled only to the extent the school provides such speech for recruiters. Anything for the money, right? The provision of an injunction against the operation of a tax protester's website, requiring him or her to place the injunctive orders prominently on his or her website, does not constitute unconstitutionally forced speech. Wow. Provision injunction. Oh, to place the injunctive orders prominently on his or her website. Wow. Footnote 12. Let's see who this guy is. U.S. versus Bell, 2005. Rumsfeld versus Formfrac. 11. Yeah, Rumsfeld. There you go. Internet generic top-level domains do not constitute compelled speech in violation of the government, since such generic top-level domains do not constitute speech. 13. Name.space versus Network Solutions. Wow. 2000. That's an old one. And we're on to section 473. Prohibition of compelling subsidized speech of others. Compelling a person to subsidize the speech of other private speakers also raises First Amendment concerns and presents the same dangers as compelled speech. The general rule is that individuals should not be compelled to subsidize private groups or private speech, or pay subsidies for speech to which they object. First Amendment values would be at serious risk if the government could compel a particular citizen or a discrete group of citizens to pay special subsidies for speech on the side that the government favors. Oh my gosh. Except perhaps in the rarest of circumstances, no person may be compelled to subsidize speech by a third party that he or she does not wish to support. By logical extension, the First Amendment also does not compel the government to compel its employees to subsidize speech. In accord with First Amendment right to freedom of speech, public employees may prevent a union from spending part of their compulsory service fees to express political views which the employees oppose and which are unrelated to the union's duties as exclusive bargaining representative. Yeah, okay. Observation: there is no First Amendment right not to fund government speech. And a government speaker is free to express a viewpoint, and the government is also free to fund the expression of certain viewpoints based on their content. There's no less true when funding is achieved through targeted assessments devoted exclusively to a program to which some assessed citizens object, rather than through general taxes. Okay, we'll see which program that was. 11. Livestock marketing. Oh, wow. What state was that? Wisconsin. Oh, wait, no, I'm sorry. It was Wisconsin. Connecticut. All right, here's our cumulative supplement. The First Amendment not only protects against prohibitions of speech, but also against regulations that compel speech. That's our NAACP case versus Hanover County, 2020. Very recent. Foods, Avocados Plus Incorporated versus, wow, 2006, 2001, Livestock Marketing Association. So we got a lot of interesting cases here. Here, let's look at this one. Holding that the generic advertising funded by the targeted assessment on beef producers is government speech, not susceptible to First Amendment compelled subsidy challenge. All right. And I think we're going to this takes us to the end of our section here of freedom of speech and of the press from American Jurisprudence. Let's hop on over here to the chat one more time. See if we catch up. Freedom is never won, indeed. It's constantly guarded to prevent its destruction by the inevitable forces of tyranny. Must be, yeah, well, the price of freedom and liberty is vigilance. So it's a never-ending effort. Some laws give a suspect a positive defense if they can dispel the suspicion that led to their detention. It is not compelled speech, but it feels closed. So there ends up being aspects with crimes in the Fifth Amendment and the Fourth Amendment that get into that. But we weren't into the criminal aspects here. Just the constitutional ones. Great subject. Yeah, well, thank you all for attending. This has been quite a long one. So salute to you all for chugging through it all, because it definitely has been quite a long section to digest, and it seems like it's so simple, and it seems like everybody thinks that the First Amendment is really just a very simple protection or securing of fundamental rights. But as we can see, it goes far, far deeper when we look at the ways that it's implemented, the ways it's protected, enforced, compelled, and other ways that affect our fundamental liberties and freedoms and our rights. So once again, salute to you all for being here. Please subscribe if you can, or hit that notification button so you will be alerted every time I go live here. It looks like the notifications didn't quite go out well this time, but hopefully next time they will. And you can always be here for the next one. Yep, to know a right is to understand its limits too. Yeah, its affordances and its limits, all essentials. Once again, thank you all for attending, and I'll see you all in the next one. Peace out.